All right, I think we have the green light here to start. So good afternoon, everyone, at least everyone who's joining from the East Coast, and good morning to those of you on the West Coast. My name is Craig Lawrence. I am a partner in the Toronto office of Dentons Canada. My practice is exclusively management side labor and employment law. I am joined today by Larissa Workwich. Larissa is a mid-level associate here in our Toronto office as well. She practices in labor and employment. And we are talking to you today about issuing discipline in unionized workplaces. As I said, both Larissa and I are based in Toronto. We practice exclusively on management side labor and employment law. We can move to the next deck. We're going to try and cover off three pieces today. The first one obviously is a biggie, issuing discipline in unionized workplaces. And we're going to try and walk through some of the substantive questions around, when is discipline warranted, some of the procedural questions around what are best practices for issuing discipline, and how to move employees through the discipline process. That's going to be the substantial portion of this presentation. And then the back half, or the back third, I should say, or quarter, will be about Bill 124, being declared unconstitutional here in Ontario. We'll also touch on the wage restraint legislation that was introduced and ultimately repealed in Manitoba, and talk about what to expect going forward if you are a public sector employer who has been impacted by Bill 124 since its introduction here in Ontario. And then again, that last piece will be a Q&A. We will do our best to get through to the questions that we can. So without further ado, let's jump into the substantive piece of it, and I'll hand it over to Larissa.
Thank you very much, Craig. And as you would have seen from the marketing materials, this presentation is going to be helpful, at least we hope, for both newly unionized workplaces as well as those that have been unionized for a long time, because it never hurts to have a refresher on the key things when it comes to imposing discipline in unionized workplaces. And that's because unionized workplaces do tend to get a bad rap, from employees thinking they can't be touched, to management's hesitancy to getting involved with employees and issuing that discipline, to just employees viewing performance management as anything that can and should be grieved through the grievance process and challenged. There's also, as I'm sure all of you listening are aware, the additional steps that come with managing performance and issuing discipline in unionized workplaces. And the big one is getting the union involved in a number of different ways. And those are steps that need to be considered now as part of the day-to-day management of the workplace. And with these dynamics, it's very easy to feel frustrated, to feel confused or potentially overwhelmed. And that's what Craig and I are here for today. We're here to demystify some misconceptions and to provide practical guidance on what to consider when it is you do get to the point where you have to impose discipline, as well as some practical guidance for the pre-disciplinary stages. And so with that, if we could turn to the next slide, and let's start with why we're here. We're here to talk about management of unionized workplaces in the context of discipline specifically, but that is part of a larger integral process when it comes to management of employees. And that includes the general operational management of the workplace, as well as the specific performance management of those employees in that workplace. And when it comes to that operational management, the most important thing, and you're going to hear Craig and I say this a number of times during this session today, is to remember that the terms of the collective agreement are what govern. Whenever a decision has to be made, whenever a step has to be taken, whether it's with respect to staffing, scheduling, or discipline, the first recourse should always be the collective agreement and taking a look and seeing what it says. And speaking of discipline, performance management in a unionized workplace is just as much of a priority as it is in a non-unionized workplace. And a primary function of managers is to ensure that employees are doing their job well. And that's true regardless of whether or not the workplace is unionized or not. And most importantly, performance, if it is not managed properly, will lead to poor performance becoming the standard. And that will not only affect employee productivity, it can also affect the reputation of the organization more broadly. And it can have an impact on the success of potential future grievances that might arise relating to that poor performance. So there's a number of reasons why it's important to get ahead and make sure that you have those operational processes in place. And now the biggest challenge or change that comes with unionized workplaces is the additional risk of grievances and arbitrations. Because in unionized environments, any concerns or employee dissatisfaction are going to be directed to the union, and that will most likely be reflected and expressed through a grievance rather than a conversation. And if those grievances cannot get resolved at an early stage, then that will lead to arbitration potentially. And both grievances and arbitration can be time consuming and costly. And so again, going back to that first point that I made, by making sure to double check the collective agreement and make sure that you are addressing performance or any other operational issues in accordance with the collective agreement, including in line with the timelines and in a fair way, then you will decrease the chances of having to spend that significant time and money through the grievance and arbitration process. And for those of you listening that are in a newly unionized environment, this process and system that I'm describing to you may seem at first glance to be vastly different from the regular processes that you would have done in a non-unionized environment. And that is true to a certain extent. However, the formal steps do mirror the processes that you would have followed in the pre-unionized environment. They're just prescribed in greater detail in the collective agreement. And in some ways that actually makes your job easier because now you have a prescribed written out roadmap to follow instead of having to figure it out or call Craig and I to give you guidance on how to do that. So if we turn to the next slide, I wanted to talk about the pre-disciplinary process. One slide back, sorry, Carla. There we go. And that's because the best thing to do is to avoid problems before they start. And that's, exactly the same thing that you would have done in a non-unionized environment as you're doing in a unionized environment. And the most important thing when it comes to management of employees is providing clear expectations and then monitoring and ensuring that you're conveying those clear expectations in situations where you see people acting not in compliance with those expectations. Because no one can improve or change their behavior if they don't know that there's an issue that needs to be addressed. And so when you see someone, an employee that's failing at meeting expectations, coaching them, teaching them, providing additional training, those are a critical first step. And it's all about trying to address why the mistake is being made and intervening as an employer at an early stage before the conduct gets to the level of becoming discipline worthy. And when it comes to coaching, you want to make sure that you're emphasizing in those conversations with employees that it is not a disciplinary meeting. It is a conversation about expectations that you're having with them in order to try and address their performance issues. And you want to try and keep that conversation, that momentum going forward and have an open discussion with the employee about your expectations, because that will make sure to get ahead of the problem. And also by making it clear to the employee that this is not a disciplinary meeting, it's a coaching meeting that will hopefully avoid their gut reaction and response to immediately jump to the union and say, I need to have the union involved in those meetings. And another important thing is to make sure that there is documentation around both the expectations and those conversations. Importantly, if you have policies that write out and clarify certain expectations, it may sound obvious, but make sure that you are actually sticking to the policy and applying those policies consistently. It's very important when it comes to the later processes that you are consistently following what it is that you say are the rules and expectations. That makes your job and potentially our job much easier. There's also a related risk of condemnation. If you have a policy, but you are not consistently applying that, and instead individuals in the workplace are being allowed to do something in a different manner and are not getting told that they can't do it in that manner. And if you allow that to go on for an unreasonable amount of time, then the employee might be able to argue that their actions have been accepted by you, and therefore that would prevent the employer from being able to assert that the employee has actually done anything wrong and more significantly, that would potentially prevent the employer from then being able to actually justify imposing discipline on the employee if the issue continues. And on a final note, I always like to mention that it's important to take advantage of probationary periods. Those probationary periods will be built into collective agreements, and the time of the probationary period will vary depending on the collective agreement. But regardless, it's a period of time that employers have to assess the performance of newly hired employees. And normally it's only after that probationary period ends that the employee is going to be placed on the seniority list. They're going to start to accrue that seniority. But perhaps most importantly, most, if not all, collective agreements are going to expressly provide that an employee can be dismissed during the probationary period if there is a reason satisfactory to the employer in its own discretion related to the performance of that individual. And it'll have that key language around the dismissal not being something that can be the subject of a grievance unless there's an allegation of discrimination, arbitrariness, or bad faith. So promptly engaging in coaching, in discussions, and making sure that people are following the policies is going to give you a record to rely on in the case that you do end up dismissing an employee during the probationary period. And that can defend against an allegation that the dismissal was discriminatory, arbitrary, or for bad faith reasons.
One thing to sort of add to that as well, Larissa, is simply that that's not to say that your collective agreement is going to prevent those grievances for probationary employees from being filed. And oftentimes, certainly newly unionized employers are confused by this. They're wondering, why is a probationary employee filing a grievance? We thought the CA actually limited their rights. That's true. But there's a distinction between whether or not a grievance can be filed and whether or not a grievance has a prospect of success. So in most cases, as Larissa says, a CA will place pretty strict restrictions on the bases for a grievance of a probationary employee being terminated, and it makes the prospects of a successful grievance quite low. Sorry, Larissa, we'll go on.
No, absolutely. That's the insight that everyone's looking to hear from us and you in particular today, Craig. If we turn to the next slide, as I've already mentioned, as an employer, you have the authority to manage employee performance, and that does not change with unionization. To the contrary, that authority is actually built right into the collective agreement through the management rights clause. And this is a clause that expressly acknowledges an employer's right to exclusively direct and operate the workplace. So this clause is going to differ from collective agreement to collective agreement, but it will include the right to suspend, the right to discipline, and the right to discharge employees, as well as the right to make, enforce, and alter rules and regulations that apply to the workplace. And so unionization does not take away an employer's right to manage the workplace, to apply policies, or to impose discipline when it is warranted. And it is the employer, not the union, that runs the workplace. So yes, the unions, the consideration of the union's role and how they get involved is something that's going to have to be considered, and that's a different dynamic change. But I always like to remind and emphasize that it is still the employer and management that is responsible for running the workplace. And with that, I'm now going to turn it over to Craig, and he's going to talk about the purpose of discipline and the related processes of disciplining employees. Over to you, Craig.
Thanks, Larissa. Carla, we can advance one slide there as well. The only part I'll add perhaps to Larissa's comments about management rights is, again, sort of keeping the focus on supervisors specifically. And again, in newly unionized workplaces, we often find that it's helpful to reinforce for supervisors that they still maintain the ability to coach employees and to discipline employees. And it's too often that coming out of a certification application or an organizing drive, there's a very sort of adversarial environment in the workplace. And supervisors can sometimes feel trepidatious about doing the things they would normally do to manage poor performance, or to manage absenteeism, or to manage just some sort of low-level forms of insubordination in the workplace. And so we do find it sometimes helpful in those environments, or even in establishing new workplaces where you have a new supervisor on staff, to give them some training to reinforce that management rights are there to protect their ability to do their job. And that a supervisor who is coaching employees, who is disciplining employees, they are not harassing employees, and that we have processes in place to help them do that. and to protect their interests and their ability to do their job as well. So when I think of a management rights clause, I think of it as sort of this core sort of enabling provision that protects all of our inherent rights. And sometimes it's helpful to make sure supervisors know that. Okay, so pivoting to the slides that's sort of in front of us right now. This is kind of that what is discipline 101 piece. And again, Larissa's already touched on this, but it bears repeating that discipline is never for the purposes of punishment, right? The goal is to correct a problem and to help an employee succeed. So punishment is not the aim. It's not part of the analysis. It's really not part of the decision-making process. Instead, when we think about how to issue discipline, we should be thinking about, well, what's the behavior that we need to correct, and what can we do to help an employee either meet our expectations or avoid the kind of misconduct that they are already in hot water over. And I tend to think of it as really three components. The first is very much about communicating to the employee what that performance issue is. And Larissa's already noted this. There's really two parts to that. One is, well, what's the standard we're asking them to meet? So we have to be able to say that we've clearly communicated the standard or the policy that they're expected to meet, whether it's an attendance issue, whether it's a behavioral issue, whether it's respect in the workplace. Identifying that front-end expectation is really important. And then showing them in really clear terms how their performance or their behavior has failed to meet that expectation. So that's stage number one, is communicating with them about, well, here's the issue, and framing it quite clearly. And then really the second part is about finding a method to reduce the risk for either additional misconduct or a repeat of the same problem going forward. So are there supports that we can put in place to help an employee attend work on a regular basis? Are there supports that we can put in place to train them on what we expect in a respectful workplace? So that's sort of the mitigating aspects of it is bucket number two. And then the third one really is about maintaining compliance with those rules or expectations or regulations going forward. And that's oftentimes where communicating what's going to happen if this behavior continues is necessary. So it's that sort of forward-looking, prospective aspect of discipline where we say, look, this is the behavior we expect you to meet. Here's what we're going to do to help you succeed in meeting the expectation. And if you don't, here's what's going to happen to you next. And all three of those components really should be a core part of the creation of any formal discipline in the workplace. And the end game of this obviously is to correct the misbehavior, to ensure that employees can succeed with us, and to put them on a path to success, and to put them on a path to being a really key component of our team. The other side of that, and perhaps the more cynical side of it, is ensuring that we are on a path to defend our actions going forward in issuing discipline. And ultimately, it's put us on a path to being able to defend a termination should it become necessary to end someone's employment. Larissa's already noted, managing someone's performance in a probationary period or behavior in a probationary period is materially different than what happens after that probationary period is over. So if your CA says your probationary period is 90 days, well, we've got 90 days with quite a bit more discretion, really, to try and manage performance. Once that probationary period is over, however, just cause protections kick in, and any discipline that we impose going forward is going to have to meet that threshold of just cause. And we're not going to short sell it here. For those of you who have worked in unionized environments for years, just cause is a very high standard for employers to meet. And the onus is on the employer to demonstrate that just cause exists for the particular level of discipline that was imposed in the circumstances. And again, although just cause is a high threshold and it requires really clear and cogent evidence to satisfy an arbitrator that we have it, terminations for just cause in unionized workplaces happen, and they happen frequently. What it takes, though, is consistency and clear processes in place on the part of an employer to establish that employees were afforded procedural fairness in how misconduct or behavior was investigated, they were given an opportunity to meet the standards fairly, and that they failed to do so. And so if we put practices and processes in place that are going to facilitate us demonstrating that those criteria were met, we're going to be able to terminate people for just cause even in a unionized workplace. So again, engaging in sort of a consistent disciplinary process is about ensuring that we can justify a termination if it comes up. if progressive discipline itself is not successful in correcting an employee's behavior. And again, when we're thinking about just cause as an end result of this, a just cause for termination, the standard to keep in mind is that we have to show that there has been irreparable harm to the trust necessary for ongoing employment. And that's a familiar refrain that you'll hear from your labor and employment counsel probably throughout your career. Well, irreparable harm to the trust that's necessary. I think that phrase is important because it sort of underscores this idea that discipline is corrective, right? We're trying to maintain the trust in an employment relationship. We're trying to create an environment where we can trust employees to meet our expectations, to not misconduct themselves. And it's really only where that trust is irreparably broken that termination of employment is justified. So grounds for discipline, we have some examples here. Honestly, you could never make an exhaustive list, and it's one of my favorite parts of my job is the creative ways that people find to get themselves in hot water. And again, it's important to think about misconduct itself as a spectrum of behaviors. And a particular type of misconduct for one employee may not result in the same discipline that it will for someone else. Circumstances and the full factual context of each case matters. That's why you can never have a matrix that says employee A engages in type B misconduct and type C discipline is going to result from it. It's not formulaic in that sense at all. But when you think about different areas of misconduct, classics like theft or assault in the workplace, these are capital offenses that are typically grounds for termination because they strike at the heart of that trust relationship. Things like dishonesty, again, I think of dishonesty not only as sort of a foundational breach of the trust relationship, but a really key militating factor that might warrant a higher level of discipline. And we'll talk about some of those little factors that we might look at when we're trying to assess what level of discipline would be important. And then you think about things like poor attendance or deficiency of work product. Okay, well, these are much more complicated and nuanced issues, right? Poor attendance, is it culpable absenteeism, right? Is it their fault that they're not showing up to work on time or on a regular basis, if they're failing to call in? Is it non-culpable absenteeism, right? It's something out of their control. So maybe there's an underlying health condition. Maybe there is a family issue that's actually protected under the Human Rights Code. There's a lot of variance in attendance and poor attendance, and having a robust attendance management policy and program in place is oftentimes the only real methodology for curing attendance issues in the workplace. And managing those employees through that process in conjunction with a robust disciplinary process is usually the best way to ensure that you have a reliable workforce. Deficient work products, again, this is about productivity. And yes, the familiar refrain is you can't terminate someone for poor performance in a unionized workplace. Well, that's just not true. You can, but it is a much longer road to hoe than it is in a non-unionized environment where you could simply terminate without just cause, pay them whatever they're owed under their contract, and off you go. In a unionized environment, we really have to take those steps, and it is a progressive process to show that an employee's poor performance continues despite our repeated efforts to help them succeed. And that can be an arduous, time-consuming, and expensive process, which oftentimes can result in more frustration. And then the last one we have written here is insubordination. I tend to class that into a broader bucket of behavioral misconduct. And insubordination itself can be somewhat nuanced as well, if only because oftentimes your loudest, most problematic employees are ones who are the happiest to have the union in place, right? They may have been organizers. They may be the ones who become your union stewards, who are responsible for conducting union business in the workplace. Those people tend to use their status as a steward as a shield for speaking to managers and supervisors in a way that they otherwise never would. And the labor relations context around that can be complicated as well, because arbitrators do often give stewards broader latitude to speak in frank terms, to use expletives with supervisors and management that other employees couldn't get away with. The hook being, though, they have to be doing it in the context of their performance of a legitimate union function. And oftentimes that fuzzy line is difficult to suss out. So in any event, we have this little list here, but I don't want you to think of it as exhaustive by any means, and the sort of case-by-case factual components of each one always matters and always drives what your disciplinary response is going to be. Carly, can we jump forward one slide? Okay, so this looks very simple on its face, right? When we're determining what's the appropriate level of discipline, you're only asking two questions, right? The first is, do we have cause to discipline the employee? And the second is, if we do, well, what's the appropriate penalty? And as always with lawyers, the simple two-part test actually has like 9 little sub-factors in it, none of which have very clear answers. But this first question, do we have cause to discipline? My mind always turns to, well, what was our investigative process, right? And did we meet a standard of procedural fairness that every arbitrator in Canada is going to expect us to have done? And procedural fairness is really just about establishing that the employee who was investigated or was alleged to have engaged in misconduct was given a fair opportunity both to hear the allegations against them and to provide a response to it before we make a decision about whether discipline is warranted and what level of discipline is appropriate. That's really all procedural fairness is about. It's about that clear communication side of things. And there's obviously multiple different ways for us to determine whether we have cause to discipline, right? There are, formal investigation processes where you might make a decision, are we going to use external third-party investigators? Are we going to use in-house staff, in-house human resources staff to do the investigation? Oftentimes, where questions of or allegations that involve management are made by an employee, either in response to allegations of misconduct or as part of their own complaint, using a third-party investigator makes a lot of sense because you avoid the perception of bias that might otherwise result. So again, how are we going to go about collecting the evidence we need to show whether or not cause exists? And answering that fundamental question of, well, what evidence do we actually have of an employee having engaged in misconduct is really, really important. Reviewing documents is important, but more importantly, it's about talking to the employees themselves to gather information and documenting those discussions with individuals, not after the fact, but when those discussions are being made, and making sure that we have a robust record of what was said and to whom, and what those specific responses were. So the investigation stage is just so key. The second question, again, sort of broadly addressed, what's the appropriate penalty? It's important to keep in mind that employers still have discretion to determine what's the appropriate penalty for a particular type of misconduct or misbehavior. And it's always going to depend on the circumstances of the case itself, right? We might look at things like the severity of the incident, right? Are we talking about theft, or are we talking about some level of disrespectful insubordination in the workplace? What was the employee's length of service, right? Do they have a long record where they've met our expectations for years and years? If so, that's going to mitigate against a severe disciplinary response, because most arbitrators will say you have a track record of good performance. This is someone who, with appropriate coaching, could probably meet your expectations going forward because they did for many years. Similarly, you're looking at their previous work or disciplinary history, and you're saying, is this a frequent flyer with discipline? Are we seeing an escalation and no improvement in behavior? Those are all factors that would help us escalate or move someone through a progressive disciplinary response. Other factors are things like honesty, right? Was the individual honest and forthright in our investigation, either with us or with the third-party investigator? And if you've used a third party, they're going to make an assessment of credibility as to whether they thought that the person was participating fully. Were they accountable in the investigation process, right? Did they admit to certain components of misconduct and deny others? What was the level of responsibility they took for it? Did they offer an apology? When did that apology come? Right? These are all components that make up this sort of complex, overlapping set of factors to examine when we're trying to suss out, well, what's the appropriate level of discipline? And I'll say on the apology front, too often, particularly with sort of heated issues, so whether it's about harassment in the workplace or other really sort of serious allegations, that apology won't come until late in the grievance process. And the reason it came, obviously, is because they've been coached by their union to make some form of apology, because they know it's so important for an arbitrator to hear those words in order to mitigate against a stiffer disciplinary penalty. So thinking again about timing, when does the apology come? Was it sincere? Was it not? Are there reasons to believe that the employee, is committed to improving going forward? All of those go into assessing what the appropriate penalty is going to be. And again, the idea is, progressive discipline always applies, But progressive discipline, again, is itself not this fixed formula. The idea is we're going to increase the severity of disciplinary response upon repeat occurrences or performance issues over a period of time, right? So we've told them what we expect them to do. We put supports in place to help them do it. We've told them what will happen if they don't improve, and then they continue to not improve. We're going to escalate what that disciplinary reaction is. Oftentimes, you'll see that kind of typical escalation being, the coaching up to the verbal, the suspensions, and maybe it's a 1 day, and then a 3 day, and then a 5 day or a 7 day. And ultimately, you're getting to that, you're discharging them for just cause. But neither your collective agreement nor any principles of law are going to say you have to do X in response to Y. There is always discretion for an employer to assess the facts of the case and move someone up more swiftly through the progressive disciplinary process than they might otherwise have done. And we always encourage, pretty robust discussion at the HR level around what should be appropriate for those circumstances. There's also the possibility that you might think about a last chance agreement as another sort of mechanism for improving behavior going forward. Okay, we can jump forward one more slide there, Carla. Thank you. This, I think, goes without saying, but it'll be repeated ad nauseum by any lawyer you work with, is document, document, document. We need everything. And that's not just formal disciplinary notices, that's coaching sessions. Now, those coaching session notes might not go in, and they probably should not go into the employee's formal record. But we want to have supervisors and managers who have maintained and keep accurate notes of their discussions with employees. Again, we're not going to put them in the employee's file, but we want to make sure that the manager has the ability to recall something from a year ago or 18 months ago that might be relevant to a new or recent complaint. And there's nothing prescriptive or magic about what process should be used, but oftentimes we find it helpful for managers and supervisors to have a notebook, to have a secure Word document that they're just punching their own notes into to refresh their memory. Because the reality is, that sort of consistent and clear documentary process is going to make your entire discipline process work more cleanly, more consistently, and produce more reliable results for you. It's about creating that consistent process, whatever it might be, and keeping in mind that documents are important, if only because memory is very fallible. And there have been many arbitrations that I've been in where a manager has been just thrilled to have their own notes in front of them that were made contemporaneous when a discussion took place, to be able to say, well, actually, yeah, I did talk to Paul about this on repeated occasions. And here was a time in 2020. And here was a time in 2021. And here are the 3 times I had to talk to him about it in 2022. And these were the answers he gave me at the time. That sort of clear, consistent documentation is in their best interests. It's just a matter of finding a good practice for making it work. Carla, we can jump forward one more slide and talk about sort of procedural requirements. I can only give you really one good piece of advice here, which is the one that Larissa started with. Read your collective agreement and always reference your collective agreement, because it is what is going to spell out those limitations on your management rights, right? So we are still big proponents of theory of implied or residual management rights. The idea being your collective agreement does not tell you what you get to do. It typically will tell you what restrictions are placed on your ability to do the things you might otherwise have done in the normal course. So it may very well impose procedural requirements on you. Do you have to give advance notice to the union that there's going to be an investigation? Do you have to disclose the nature of the investigation to the union in advance? Do you have to have a union rep present in an investigation as opposed to a disciplinary meeting? Do you have to have a union steward present when a witness is being interviewed as part of an investigation? The only place where that stuff is going to be spelled out is your collective agreement. I'm not going to get into the sort of convoluted web of what past practices can do and how it can screw up clear language in a collective agreement, but your starting point should always be your CA and going back to reference it. From a procedural perspective, assuming your CA is relatively straightforward on when a union has to be present and what advance notice is required, we want to be conscious of the need to set those allegations out clearly to the employee, get their response, make sure we have records of that response, and that we haven't made a decision on discipline until we've given that employee a fair opportunity to address the allegations against them. That's that core of procedural fairness that we already spoke about. make sure that we're being timely in how we're investigating these things. Sometimes it's not within our control, right? A complainant doesn't come forward until a year later, and they sat on an allegation not because it wasn't serious, but because they didn't want to deal with the perhaps coworker follow-up that could result from filing a complaint. All we can do is control what's in our hands, and when we get complaints or when issues of discipline come to us, we need to be acting timely and communicating in a timely fashion. This last piece about sunset clauses, again, your CA is going to spell out whether a sunset clause exists. And all that really means is there a period of time after which any discipline on an employee's file has to be removed from that file? And there are different types of sunset clauses. Some might say the discipline comes out, but reference can be made to the incident itself. Some might have different time periods for different types of misconduct. It might say it's removed after 18 months for verbal or written warnings. Any discipline issued in connection with harassment will remain on the employee's record indefinitely. Your CA is what governs that and will dictate, what discipline can we rely upon when we're trying to assess, what's the appropriate level of discipline in this particular case. Because any discipline that's been struck by a sunset clause, it's been removed from an employee's file, we really can't rely upon it, subject to the language of the CA, when we're trying to assess what's the appropriate level in a particular case in front of us. Okay, and with that, I'm going to turn it back to Larissa. And Carla, I think we can advance one more slide.
Thank you, Craig. So up until now, we've been talking about disciplinary processes and the pre-disciplinary processes and our recommendations as well on making sure that you're set up not only to engage in those processes, but to have the records and documentation related to that. Now we're going to shift gears and talk about probably one of the bigger, if not the biggest, dynamic changes that comes with unionization, and that's the grievance process. Grievances do have a negative connotation associated with them, and that's likely due to the time and cost that comes along with them. But we did want to touch on that because they are an important part of what a unionized environment looks like. And at a high level summary, a grievance is the process through which issues are resolved between the union and the employer, issues that relate either to a specific individual employee, issues that relate to a group of employees, or issues that may not specifically be impacting one person, but the union has a concern or an issue that they would like resolved through that process. That's what it is. It's a process through which things are resolved. It's just a formally structured process. And so my preliminary advice, and I'm sure Craig would echo the same thing, when you do get a grievance form and you receive that, try not to get stressed out over having a grievance filed. Grievances will happen. Some grievances are won, some grievances are lost, and that's just part of being in the unionized environment. And we've talked a lot up until this point in the session about trying to resolve issues before they become grievances and trying to make sure that you have those processes in place to impose the discipline and correct behavior in the workplace. And that is important. But sometimes that can or won't happen, and the grievance is going to come, and that's perfectly fine. And to echo what Craig said, it's not the question of whether or not you do or do not get the grievance. It's the question of whether or not you have the justifiable basis to show why you took the steps that you did, why those steps were warranted, and that the response was reasonable and that it was procedurally fair in accordance with the collective agreement. And so there are generally 3 different types of grievances contemplated in the collective agreement, and I've already given a high-level summary of those. The first is the individual grievances, and that's complaints where there's a violation of a specific individual's right under the collective agreement or under law. So an example would be, let's say that an employee says that they didn't receive their holiday pay in a certain pay period. Then that would be an individual grievance that they would file to get that pay that they're saying they are entitled to. Group grievances are situations where there are a group of individuals that have been all affected in the same way. So to build on the example I just gave, let's say there were a number of individuals who are all working the same day, and all of them are saying that they weren't provided that holiday pay. Because multiple of them have been denied the same entitlement, they could proceed through a group grievance, which might have slightly different processes depending on what the collective agreement says. And then lastly, you'll have the policy grievances. And these generally are complaints by the union that there was some action or perhaps inaction on the part of the employer that constitutes a violation that could affect the rights of the individuals that are contained in the collective agreement. And it's the nature or scope of the subject matter that is making it one that necessitates starting usually at a higher level of the grievance process than just an individual or perhaps a group grievance. So an example would be, let's say that a new shift was created, and that new shift was created in a manner that wasn't consistent with what is required in the collective agreement, then the union would have the ability to commence a policy grievance related to that. And each collective agreement is going to prescribe the specific grievance procedure that must be followed. And it will vary, both in terms of timelines and the deadlines for which things have to proceed to the next level, in terms of what is or isn't considered one of those types of grievances, in terms of what can or can't be grieved. And that's why, again, to echo what we've been saying, the first thing to do when you do get a grievance is to immediately turn to that section of the collective agreement and make sure that you are refamiliarizing yourself with what the timelines are, what's required, who needs to respond, when, etc. And some collective agreements will also, as I've noted, say that certain grievances can escalate through the process at a higher step, meaning they will start at a different level. So you want to make sure that you are reminding yourself about what types of grievances will start at which stage, because sometimes you'll get into a situation where you assume it's starting at an earlier stage and follow those timelines, but in fact, there's additional timelines that are required to be followed. And if we turn to the next slide, same explanation and caveat that Craig gave. We like to summarize things in simple questions that have a lot of background and context to them. And that's the case here with grievances. So if you do get a grievance, there's two questions that you want to ask yourself. The first question is, what kind of grievance are you dealing with? So going back to that explanation that I gave, is this an individual grievance? Is it a policy grievance? What scenario am I working with here? And then the next question is then, what stage in the grievance process is the grievance procedure going to start at? Now, I say that's the first question that you should ask yourself, but I was perhaps a little bit misleading, because there's actually one step that you should take when you get a grievance before you ask yourself these questions. And that is to review the grievance form that you have received in detail to make sure that all the information is captured, and importantly, to see what day the grievance is filed and what date the incident or conduct or decision of the employer is relating to. Because there are often situations where you might from the start have a timeliness issue, meaning that the union did not file the grievance within the time limits that are prescribed in the collective agreement. And that is an easy, it's not necessarily going to immediately resolve the grievance, but it is a potential consideration before an arbitrator if you do get to the situation where you have to decide whether or not this is something that goes forward. And if it's been a year and the issue was not brought to the employer's attention until a year later, then you might have a stronger argument to say, sorry, this is not something that can now be grieved because you didn't comply with the time periods, as opposed to, let's say it was just a day off from the time periods. You're likely to have an adjudicator say that, that was a small oversight, but doesn't warrant getting the grievance thrown out. So it will depend, but that is always an important thing to take a look at and keep in mind, because you want to make sure if there is an issue with timeliness that you're raising that as soon as you possibly can, and not sitting on that until you actually get to the hearing stage.
And oftentimes employers, especially newly unionized ones, can be frustrated at the lack of information on that grievance form itself. Right? It may be a stock form from Unifor, and all you get on it is discipline unwarranted, remedy requested is full redress. And that doesn't really tell you a whole hell of a lot, let's be honest, and it can be a big source of frustration. And unfortunately, the case law on this is not particularly helpful for employers. So what we generally say is, the level of specificity that you're going to get on your grievance forms is dictated both by relationship. So have you fostered a pretty open and clear line of communication with the union who's prepared to tell you exactly what the basis of the grievance is? And two, have you negotiated language in your CA to make it an obligation on them to actually provide you with full particulars and the facts behind their grievance? So I flag that just as an issue because it's such a common area of frustration around very vague or in some cases just, a very brief, if not abbreviated grievance forms.
Yeah, absolutely. And I think it builds nicely into what I was just about to talk about as well, which is when you do get the grievance form, take a look, gather whatever documents you might have or notes or records that relate to the incident that you've been made aware of. But to the extent that there is information that you don't have, or you have questions about what the union is grieving, that's partly why those steps in the grievance process have been included in a collective agreement, is to allow that opportunity to have the initial discussion between the union and the employer before you actually get to the arbitration stage. And so a lot of times those meetings will be viewed just as a formality that has to be done as part of the grievance process. But in some situations, you can use that as an opportunity to ask the union the questions that you have, to get some clarification on the context, and to see whether or not through that open communication, you might be able to resolve that grievance at one of those stages without it actually getting to the arbitration that could potentially be looming. And so in all of these processes and all these steps, when you're thinking through, and as Craig noted, you might get that initial frustration or anger that you're not being provided certain information in the grievance form. I do like to recommend to just take a step back and try and approach the grievance calmly and with an open mind, because that will make the process easier for you, and it can help open you up to that potential for resolving it, as opposed to immediately coming in with that adversarial mindset. And with that, I'm now going to turn it back over to Craig, and he's going to talk to you about when you have to call the union.
And you can advance one slide there, Carla, please. I'm going to try to be brief on this because we would like to speak on Bill 124 before our time is up. The most important thing here is that first bullet. It's going to be spoken to in your collective agreement. When you have to have the union involved in a disciplinary process, your CA will be explicit about it. Some are better drafted than others, obviously, but there is always going to be some nuance to when the union has to be called. And I think there's a distinction between what happens at things like a labor management meeting, which oftentimes, again, CAs will speak to, quarterly labor management meetings where the parties come together to discuss workplace issues. That is not a forum where we should be addressing outstanding grievances. We should be keeping the grievance process discrete and separate and part of its own dynamic. But your CA is also going to say, well, when do you have to have a steward present? When the union has to be notified of an issue in the workplace? And there's different versions of those disciplinary meetings clauses. Some will read, a steward has to be present in a meeting that could lead to discipline. Some say that they have to be present at meetings where discipline will be issued. Some say that they have to be involved at the investigation stage. And in fact, that's something we're seeing at the bargaining table a lot, particularly from the national unions, is they are trying to convert investigation rights, which are intrinsically a management right, into bilateral rights, where they are explicitly entitled to participate in investigations. That means they get to receive copies of investigators' reports. Obviously, my view as a management side lawyer is that is a remarkable intrusion upon a core management right, and you should be loath to give it up. So unless your CA is telling you have to involve them in things like that, I would likely tell you that you should not, and you should preserve as much independence and discretion as you can. But your CA might be broader than just discipline, right? You may have an obligation to disclose in advance whether layoffs are coming. You may have an obligation to sit and meet to discuss ways of avoiding layoffs. You will have obligations, whether the CA speaks to it or not, to tell the union in advance of any permanent plant closures or facility closures. This is particularly true if you're entering a bargaining context. So from the context of a disciplinary issue, and that's what we're talking about today, your CA is almost always going to be explicit about when the steward has to be involved in the disciplinary process. These other pieces, around technological change and modification of work schedules, oftentimes your CA will be explicit on them as well. But we always encourage you to contact your lawyer if you have uncertainty around whether or not you need to reach out to the union. And again, when in doubt, read your CA. It is the very first thing your external counsel does. It doesn't matter if it's me or Larissa or a different law firm altogether. The first thing they're going to do is pull out your CA and say, oh yeah, what did that specific clause says? There are lots of clients who might have 60, 70 CAs across Canada, and knowing which nuanced CA you're dealing with is really key to understanding what role the union has to play, if any, in your disciplinary process. Okay, with that, we're going to jump to Bill 124 with the few minutes we have remaining. And Larissa, over to you.
All right, and I'm going to keep this this brief so we can get to the real interesting part of this, which is the impact and practical considerations going forward. But for those of you who didn't hear the words Bill 124 repeated over and over again in the news a couple of weeks ago, this was a piece of legislation, and we can go to the next slide, Carla, that was brought into force in November of 2019. And the intention was to ensure increases of public sector compensation reflected what the province perceived to be the fiscal and financial situation of the province at the time, and that it reflected fiscal management and protecting the sustainability of public services. So that's a long-winded way of saying that it imposed compensation increase caps on employers in the broader public sector. And that was both unionized and non-unionized environments. And the way that it did it is it imposed a 1% cap on compensation over each 12-month period in what was referred to as the 3-year moderation period. So this legislation, to those of you that weren't impacted, it impacted broader public sector organizations, including those that receive a certain amount of funding from the government, hospitals, school boards, universities, etc. About 700,000 employees in Ontario were impacted by the legislation. And there were some exceptions to the 1% cap, but those exceptions were very limited. So what happened? 10 applications were brought by both unions and labor organizations to challenge the constitutionality of the legislation. And those applications were heard in consecutive order over 10 days. And the court made a decision on whether or not it was unconstitutional. And specifically, the challenge was that it infringed on 3 rights: freedom of association, freedom of speech, and equality rights. But the crux of it was the freedom of association, which is the argument was that this bill was substantially interfering with the right to collectively bargain. So if we turn to the next slide, what happened is that the Ontario court held that Bill 124 did not restrain freedom of speech or equality. However, it did substantially interfere with collective bargaining, and therefore it violated the Charter. And not only that, it could not be saved by Section 1 of the Charter, which requires a consideration of whether the infringement is demonstrably justified in a free and democratic society. And this is because the court held that the Ontario government did not demonstrate that the economic situation in Ontario was sufficiently critical to warrant infringing on this constitutionally protected right of freedom of association. And as part of the decision, the court considered another decision of the Manitoba Court of Appeal related to a similar piece of legislation. And so I'm going to turn it over to Craig so he can talk about that, as well as the impact of the declaration that Bill 124 is unconstitutional. Over to you, Craig.
Thanks, Larissa. And Carla, we can jump forward one slide. And I'm going to be very brief on this Manitoba piece, but if you can forgive some law nerdiness just at the tail end here. I mean, the arc of the right to strike as being a charter protected right has been really progressive over the last 30 years. 15 years ago, when I was coming out of law school, we were still very much talking about how the right to strike had only recently been really enshrined and protected. And so the decision here maybe is not surprising given the arc of how the Supreme Court of Canada has historically viewed the importance of the right to strike under the freedom of association. The one sort of I think, wrinkle on that was this Manitoba case in 2020. Manitoba had introduced its own fiscal restraint legislation back in 2017. It was actually more restrictive than Ontario's. It actually was a 4-year restraint period. It imposed a 0 and a 0 in years 1 and 2, and then a 0.75 in year 3 and a 1% in year 4. So again, more restrictive than Ontario's. The key distinction, though, being here that it was never actually proclaimed, so it was never enforced. So it was passed but never put into practice. So in 2020, the Manitoba Queen's Court, or Queen's Bench rather, strikes it down and says it's unconstitutional. It's a violation of the Freedom of Association, and is sort of in keeping with this history of Supreme Court of Canada decisions. But then strangely in 2021, the Manitoba Court of Appeal reverses it and overturns it and says, well, actually, no, we don't find substantial interference here with the Charter protected right, and we're going to allow it to proceed. All of this is only important because the Supreme Court of Canada declines to hear the appeal from the Court of Appeal in Manitoba, and then Manitoba's government changes in 2021 and they repeal the thing anyways. So it was never enforced, which is important, and it was repealed. So it's all a bit of a much ado about nothing, and the factual foundations of that case were just radically different from what evidence was in front of the court here in Ontario. So Carla, we can jump forward one. But I think, people who were expecting Ontario to follow the Manitoba Court of Appeal decision, that was perhaps some misplaced optimism, just because the factual foundations were so radically different. In Ontario, even the budget evidence that was led in court was pretty damning for the government's case. And ultimately, the court found on its own facts in Ontario that there was substantial interference with the right, which is the baseline way to distinguish those two lines of cases. So anyways, what does this mean for us going forward? Like, park all the law nerd stuff. Well, the Ontario court has declared it void and of no force in effect. So as of right now, Bill 124 no longer is in force. That means that employers can increase compensation over 1%. There is no longer any moderation period. And ostensibly, there's going to be some sort of knock-on consequences from that. The government of Ontario has stated that it plans to appeal the decision to the Court of Appeal. It has that right of appeal. But as part of that appeal, they don't necessarily get to stay the lower court's decision. And a stay would essentially mean Bill 124 stays in force while this appeal is heard. But the stay is not automatic, and the government would have to seek a stay in court. And that test is in and of itself pretty hard to meet based on the decision that we have in hand. Because at the end of the day, they got to be able to show that there's a serious issue, there's irreparable harm, and that there's a balance of convenience, all of which is a fancy way of saying they got to convince the court that there's a likelihood of success on appeal. And given the way that this decision is drafted, that seems like it's a very uphill battle. So even if the government appeals, very likely that there may not be a stay of proceedings, and so Bill 124 would still no longer be in effect. Obviously the government could also try and use the notwithstanding clause, which got a lot of media attention in context of the teacher strike, which essentially says, look, even though there's a charter violation, we get to do this for a time limited period. Again, no indication that is actually, steps have been taken to do that yet. All of which leaves us in a bit of a limbo. Not limbo in force of law, because the answer is quite clear. Bill 124 doesn't exist right now. The knock-on consequence of that for us is obviously look at your CA. There are lots of CAs in the broader public sector, including those for not-for-profit organizations that were receiving at least $1 million a year in funding from the government. Their CAs have reopener clauses in them because most of the unions had actually piggybacked on this lawsuit. And so in bargaining over the last 3 or 4 years, sophisticated unions had said, as part of their renewal CAs, the agreement will be reopened if Bill 124 is struck down. There are dozens of different reopener clauses, and the specific language of those clauses matters quite a bit to determining whether or not your reopener clause is triggered, and whether you would have to go back to the table to ostensibly negotiate retroactive increases for the term of your existing CA. So look at your clause, look at your reopener, consult with external counsel, certainly on an issue that's that important. The remedy for the breach itself, the court has reserved on. So they're going to hear that matter at a future date. But the financial consequences of this are likely to be quite significant. The Financial Accountability Office of Ontario, the FAO, they had put out an estimate, I think in September, for prospective costs and retrospective costs. And the FAO, I think, had said retrospective costs, or retroactive costs rather, for the breach is likely in the range of $2.1 billion. Forecasted prospective costs for public sector employers in Ontario is around $8.4 billion over the next 5 years. This is again anticipating that those unions who were subject, and those workers rather, who were subject to the 1% cap are going to be looking to renegotiate those deals and play catch up, particularly given the economic circumstances that we find ourselves in, and the looming threat of a recession next year. All of which is to say, I think if you were subject to Bill 124, you should be speaking to counsel around what the consequences of this decision are for your collective agreement and for your fiscal forecast, particularly if you have an existing CA with this reopener clause, or if you're approaching bargaining now, because I think that certainly the economic landscape of union demands is going to change quite radically, quite quickly. For you non-unionized folks, same thing. You no longer have fiscal restraint. You now have full discretion to provide increases as your organization sees fit. Those are all of our comments on Bill 124. We have some questions in the deck. We are already over time. I'm happy to sort of tackle some of those questions right now, and then obviously we're happy to follow up following this as well. The one that I had sort of noticed right out of the gates, just when Larissa was giving her last section, was whether or not third-party investigators typically provide a recommendation for discipline if it's warranted, or do they only do fact-finding? This is a really great question and a really important one. I think almost any good external counsel is going to tell you, do not have your investigator make recommendations on discipline in their report. That is not the function of a third-party investigator. Third-party investigator is there to collect the facts, make an assessment of what they think happened, make assessments of credibility. They can tell you whether or not it's their view that a policy was breached. But the question of whether discipline is warranted and what that level of discipline should be has to remain with you as the employer. And you have to be assessing that after you've had a chance to review the investigation report. So any investigation report that tells you what the discipline should be, even if we are justified in the recommended approach, the allegation from a union is going to be, you've breached procedural fairness, you actually made a conclusion on discipline before you had a chance to review the investigation findings, and you've breached the fundamental principles of natural justice, and the discipline should be void. So that's, I think, a really important one. If you use third-party investigators, even if you use internal investigators, I often will say, do not have recommendations on discipline in the report itself. And keep in mind that in almost all situations, those reports are producible in an investigation arbitration. So all those notes, those drafts are likely going to have to be produced to the union, and we want to make sure that that process is quite clean. We have a question, but can we explain condonation? Larissa, do you want to tackle condonation for us?
Yeah, absolutely. So in a nutshell, it's a situation where somebody is engaging in behavior that is inconsistent with the rules or inconsistent with the policies that you have, but because they do it over and over again and no one is telling them that they're not allowed to do it, it effectively means that you've condoned that behavior, and therefore it makes it more difficult for the employer to then impose discipline or take action against that. Because if someone has been doing something in a certain way for a period of months, if not longer, and then all of a sudden the employer comes in and says, you're not allowed to do that, here's our policy, and they can point to that past practice of doing it for that period of time, it makes the foundation of your ability to procedurally impose discipline a lot weaker. And that's why all of our conversation around timeliness, around making sure that if there are issues that are arising, you're addressing them as soon as they come to your attention, are so important, because that will help avoid situations where there is a practice that's gone on for a number of years and you're now trying to correct that, but your job is a lot more difficult because the individual can say that they have been able to do it that way for a long time.
And there are really simple examples of this, right? I mean, but they can be quite costly. So you may have a clause in your CA that requires an employee to obtain approval for overtime before working that overtime. If we haven't actually required them to do that, then you may have quite a bit of difficulty in enforcing that language of the CA before the conclusion of that CA. And that gets into questions of estoppel and ending estoppel and curing past practices that are inconsistent with the terms of your CA, all of which is something for a different day and a different session in this series. I have received a note here. We are now at least 8 minutes over time. So we are going to wrap up. We do have these questions in the Q&A. We will make sure that we reach out to you with our answers on them. And again, we do solicit any questions you might have that come out of this that we didn't have a chance to tackle. Always feel free to reach out to Larissa or myself or any other team member here at the Denton's office. And we appreciate all of you for joining us today on this session. And we hope that you will attend our future sessions in this seminar as well. So thanks very much, everyone.